My speech is about the position of the prosecutor before ICC, and I must say that the location of my speech is exact, as I would like to speak about the position of the prosecutor from the point of view of the effectiveness, as it is the necessary point to assess this figure in the process. Obviously, I prepared the theoretical part and case law, and I don't have that much time to present all of this, so I will try to present from the end. I will try to concentrate on the main part of my speech. So first, of course, I would like to discover who is the prosecutor before ICC. As we know that the model adopted is a hybrid model. So I have some observation in this regard, how this combination versus prosecutor is achieved. And then I would like to assess the effectiveness, but having reference to the previous speaker, I would understand effectiveness broadly. So I would like to distinguish effectiveness and efficacy. So I think that effectiveness is not only about the cost and the time, but also the purposes, especially when we speak about the tribunal, those purposes, goals expressed in preamble, as for example, the principle of truth is a very important part of effectiveness. Having in mind the practice of ICC, I think that we must understand the guarantee taken into consideration, the fair trial aspect, not only the given conviction before ICC, to be honest. So obviously the one assumption must be made that I'm as a scholar, and I think that I see the space for a bit a critique versus tribunal, and not only maybe tribunal, but the foundation. So I would suggest some amendments, which obviously I'm aware are not possible to be introduced, but just observing the adopted model from this 25 years perspective, I see this as an honest solution to present some amendments, as the Lege Ferenda postulates, which I locate mostly in respect to the principle, accusatory principle. So the moment when the charges are presented and confirmed by pre-trial chamber, and the dispositiveness at this point of prosecutor, who is, regardless of the model adopted, still under the control of the court. So these I see some point to maybe reshape somehow and someday a procedure. And obviously, I would try to observe this position in dynamic perspective. I mean, this position through the subsequent stages of the procedure, which is connected with the dynamic position of the prosecutor. So the challenges. So the challenges of the position of prosecutor I see with this first dynamic assumption that the prosecutor plays a double role, but under the Rome Statute, prosecutor is mainly the officer of justice, and at the same time, adopted model initially have been taken as adversarial model. So see, this is an initial challenge in this procedure, that we have an officer of justice who plays the role of the party before the court, in opposite to defendant, who is at the first moment someone without name, someone without name in the sense of civil law procedure. We don't have suspect in this procedure. We have someone against whom the arrest warrant has been issued. We have someone against whom subpoena is issued. We have someone against whom charges have been confirmed, and this is a moment of a defendant who appears in formal sense. And all this time, the prosecutor is firstly the officer of justice, so we must denote the moment when the prosecutor starts to play the role of party, which is very important when it comes to evidence-taking procedure, and I will try to address this somehow in my speech. I will try, and at least I will present this in paper. So First of all, my assumption is does the rule of the officer influence the rule of the party to the trial? And my hypothesis is the most procedure advanced, the prosecutor has less discretion. This is a quite obvious hypothesis, but this hypothesis might be presented in detail with some proposals. And challenges which I see more strictly is the structural fluctuability of this procedure. So when I speak about fluctuability, I think that this procedure, when it comes to the frames and the subsequent stage, is much more flexible than the procedure before national courts, and even much more flexible than the procedure before other international courts, especially ad hoc tribunals. So from this point of view, here I see the challenge, how to combine this fluctuability of separate stages of this procedure with the rule of prosecutor and his discretion, which I understood through the principle of opportunism. Yes, as a prosecutor is dominus litis somehow during the first stage of procedure, but still under the constant control of pre-trial chamber when it comes to the sphere of the subject matter of the case, especially discontinuation of the case. It's a constant control of pre-trial chamber, so we cannot say that he's a dominus litis entirely. And if not mention the position of political bodies, Security Council, which is authorized to stop the procedure, suspend the procedure for a while, even not once. So this control is obvious. So I would see the opportunism principle shaping the position of prosecutor as a gradual opportunism. In negative formula, it means that the greatest discretion is at the beginning, and then when procedure advances, it is less and less discretion in the hands of prosecutor. The Lege Ferenda postulates, I will start with them due to the limited scope of my presentation. So when thinking about the whole procedure, what can be amended to enhance this rule, the effectiveness of the prosecutorial position in this procedure, I think that the first, I would agree with those authors who would try to insert some time frame when it comes to the preliminary examination. I think that this obviously, it must be in reasonable time, but we know also that the prosecutor already disputed with a chamber about whether the information must be given to the addressee, the person who referred the situation. In Central African country situation, it was this dispute between the prosecutor and chamber, whether prosecutor can be somehow forced by pre-trial chamber to inform, decide on the situation. So I think that this proposal is quite reasonable. Obviously, it cannot be somehow strict term, but somehow obligation due to, for example, 2 subsequent years to issue some sort of provisional decision can be implemented. And the second postulate is more abstract. I would say this concerns the part of the Rome Statute, which I see in connection with the accusatory principle, and I would claim for more discretion for prosecutor, especially at the moment of confirmation charges, and after. I would say that this solution adopted about the withdrawal of indictment with a confirmation authorization of court is very hard to combine with adopted model of adversariality and the interaction between defendant and prosecutor. So I would suggest through the examined case law that this would be a small part of this concept that can be seen as enabled to be adopted and amended someday. And then terminology. My observation is that the Rome Statute operates under maybe not the best terminology when it comes to the notion crime. Crime and it's the use of this term when it comes to the procedure in pre-trial stage. I think that this would be more protective to use the notion the prohibited act, which we don't discover hold the grounds to prescribe a responsibility of someone, and these are some observations and some suggestions to amend the part of legislation, maybe in future, or just as observation which can be taken into consideration by the court when elaborating on those terms and legal interpretation, which I see as a broad topic. I think that I asked Justice about the activism of court, but because I see the large place for the activism for interpreting creatively the statute by the court. In the written form, I will present consideration about the case, which also I would argue with some scholars, because mostly the case is understood in status as objectively and subjectively oriented. But I would say that legislators rather thought about the case in continental mode. The case as in rem starting of prosecution also is admissible, this understanding is admissible based on the statute and the rules for procedure and evidence. So organizing the position of prosecutor, to be short, I would argue about those collections of features and principles. Firstly, the stadiality regarding this progressive approach of the rule, the set of guarantees which are in the hands of prosecutor to ensure the position of the other participant to the procedure, and the principles. Obviously, I don't have time to elaborate all of them, but those are the most important, mentioned before, opportunism versus legalism. Here is interesting observation that obviously, we act when speaking about ICC based on complementarity principle. So obviously, we cannot operate traditional notion of legalism as it is encoded the principle that each crime must be prosecuted. And obviously, this is not a goal of ICC. ICC must act in this manner to ensure justice all over the world, but the aim is not to prosecute each crime committed. It's selective responsibility. So we operate with legalism just in the sense that when the case has been selected and then defendant was selected, then maybe we can speak somehow about introduction the principle of truth in practice of tribunal, and then at the end about the legalistically oriented attitude of the court. But just after the whole selections have been made. So this is a pure opportunistic approach. And this material truth combination I see also as a hard task for the prosecutor and even for the court, which is obviously noble, as it was mentioned before, that the court can operate only in the frame of principle of truth. But at the same time, the adopted model must be seen as controversial combination of all those adopted features. And my goal also is to establish somehow historical background, which is important when speaking about the position of prosecutor. And here I just mentioned one aspect, this form of acting. While during the activity of military tribunals, the prosecution's party acting collectively, then we adopted through the ad hoc tribunals and special tribunals this individualistically oriented attitude. So there's someone who is a prosecutor, the one who is an officer of justice, but obviously it is not the one to realize all this task. And about this, I want to also argue somehow in this speech. So the prosecutor, based on the status, must be distinguished from the office of the prosecutor. And from this perspective, as we can see maybe on the picture, it is obvious that there are some rights connected with the office of a prosecutor, but then the prosecutor plays this double role of officer and the party, and some obligations are directly connected with the office of prosecutor. And when we speak about objectivity, we speak more about the office, not about the person, because when we speak about the person who is a prosecutor, we have this regard that the prosecutor will be a party in the trial, opposite party to defendant. And here I have one important question to address. So who is the tutor of the substantive truth principle? Whether this is a prosecutor during the whole trial, it was also the issue addressed by pre-trial chamber at the several occasions. So whether prosecutor is bounded by this principle of substantive truth during the whole process, or only until the charges are confirmed. Obviously it is longer, but whether during the whole trial. There are some features in favor to this hypothesis, that he is obliged by the principle of truth during the whole trial. But on the other hand, I think that this is at the end the court to adjudicate, and this is the court who must somehow guide the activity of prosecutor before the court, even though the adopted procedure is adversarial, which is this paradox in the given model. So I think that the guardian of substantive truth in prosecutorial part, I see at some point, a more procedure advanced, the less obligation on prosecutor with regard to principle of substantive truth remain. And speaking about this whole postulates, the first postulate about the actions of prosecutor examine several cases, but up to the point to be more insightful, I see those activity connected with the first postulate to introduce the time frame for examination procedure. We can observe, to praise the court, that there are several new tools introduced to improve the practice of pre-trial examination, even though I'm rather skeptical entirely to these new tools, and one of them is the OPT link platform, when everyone using by this platform can introduce information to improve the prosecutorial activity when it comes to the first stage, it's not even stage, the first moment to start somehow phase of future maybe prosecution before the ICC. And obviously, one can say that this enhances the prosecutorial activities, but on the other hand, I would say that the principle of credibility of then pieces of evidence is under danger, as at the same time the prosecutor must carefully examine those information, especially when it comes to whole audio-video registration, for example, or private registration, and whole development of artificial intelligence and deepfake technology seems to me very dangerous through this openness for gathering information. So I think that at the same time, there is a need to enhance prosecutor in this technical part of operating on the material. Obviously, some tools, some electronic tools could be promoted in this regard, some algorithm. So the more important part of this platform, and to shorten the first part of future procedure before ICC, I perceive as maybe controversial, but it is a very good point to enhance the prosecutorial position during this first part. And what is important now to get to the somehow conclusion or the more important part of my postulate about about the hypothesis here. Hypothesis. When it comes to the first dynamic perspective, so investigation, I think that the prosecutorial activities, of course, remain in balance with the activity of pre-trial chamber. They are under this balance when it comes to initiation of investigation, but mostly about discontinuation of investigation. And the fragile point I observe when it comes to generally evidentiary actions, and especially actions upon in favor of future defendant. And whether the court is the one, the pre-trial chamber, who guide the prosecutor toward those activities. As we know that during the court, the prosecutor then is obliged to present whole evidence in favor of defendant, but everything is in the hand of prosecutor. So my suggestion, speaking about this reshaping of adversarial procedure and accusatory principle somehow at this point of transition, is to maybe rethink the moment of disclosing information. As we know that this moment during the first phase of procedure is not given. So at the moment of confirming charges, the prosecutor is showing just a part of information. It is not the full file of the case. Then is the moment that the prosecutor is obliged to show other pieces of evidence and information that enhance the position of defendant, but still there are not whole files. So I think that if we want to have adversarial models somehow, we must better define, and this could be the place possible to achieve even through the some proposition by the judges or even prosecutor of ICC, as the rules of evidence and procedure shall be amended in this regard. So the moment to disclose information, to introduce this moment before, and at least at this periodical stage of procedure connected with confirmation of charges. Obviously, I know that this is a specific feature, confirmation of charges of this procedure, and from this scholar, professor analytic point of view, it's very interesting. But I must say that this procedure is shaped rather in favor of defendant, but when at the same time defendant is not aware about whole documents and files of case, this procedure is somehow illusionary. And obviously, speaking about the situation of prosecutor, one of the core question is how to select defendants, and also this will be a big part of my speech, how to select defendant and when to select defendant and when to make them aware about the complex of charges. As we know that during the pre-trial stage, this awareness, actually the performance of the right to know the charges is also very flexible, as during this procedure of issuing arrest warrant, there is somehow the first attempt to formulate charges, and then it can be reshaped, and even after confirmation of charges, this can be modified. So when this transitional model of prosecution, so as I stated at the beginning, I see the challenges for the position of prosecutor through this point of fluctuability of procedure and combination of the double rule of prosecutor with several principles, especially the principle of truth and the burden of evidence, which is under the prosecutorial shoulders, but it is also the question at which point who must be responsible during the trial to enhance the principle of truth. Thank you for my speech. Thank you for your